evening, everyone. I'm really happy that you could join the Legal Aid Society this evening, where we will be speaking about heirs properties. And before we get started, I'd like to introduce myself and my co-presenter. And my co-presenter is Malbrough. He is an attorney and an Equal Justice Works Fellow, and he works here at the Legal Aid Society. And he helps homeowners create estate plans, navigate the probate process, and address various heirs property issues. Miles is a Tennessee native, a graduate of Vanderbilt Law School, and is passionate about helping people keep their homes in the family so that future generations can benefit from it. My name is Patricia Jones, and I have been with the Legal Aid Society for 9 years. I'm the managing attorney of our Columbia office, and I lead our home retention team, which has allowed me to have the opportunity and benefit of working with Miles on his heirs property project. And he has taught me a lot, and I'm super excited that we can be here this evening and share all the information with you. So before we get into talking exactly about heirs properties, I want to let you know a little bit about what the Legal Aid Society does. And we are a 501c3 private nonprofit law firm, and we provide education, representation, and information about various different civil legal matters. And we focus on helping low-income individual families and folks who wouldn't normally be able to afford legal services. Our mission is to advance, defend, and enforce the legal rights of low-income and vulnerable people in order to secure for them basic necessities of life. We want to try to help everybody get through this world in the best possible way. And we are the largest nonprofit law firm in the state of Tennessee. We not only provide direct representation, but we also provide resources and education to the community. We help in 48 different counties. And across those 48 counties, there's over 360,000 people that are at or below the federal poverty line that would qualify for our services. That means for every one attorney, there's at least 8,000 people that need our help. So we're super busy. We do have 8 different offices, and you can see here from the map where those are at. As I mentioned, I'm in Columbia, and Miles, our other presenter, is from our Gallatin office. But we also have offices in Murfreesboro, Cookeville, Nashville, Clarksville, Oak Ridge, and Tullahoma. And we have several areas of practice, as you can see on the screen: bankruptcy, consumer protection, education, elder law, employment, family law and domestic violence, health, housing, immigration, juvenile law, mortgage foreclosure, which is what the home retention team does, public benefits, and tax disputes. That's basic information about the Legal Aid Society. If you want to learn more about us and what we do, you can go to las.org. There are community events that we post there. There's also personal resources you can use, informational stuff there, just all the good stuff there. We also do fundraisers, and you can learn more about that there. And again, that's las.org. But now that we're done with that part, I do want to get started on our heirs property presentation. Just before we start, we always tell folks that the information you're going to hear cannot take the place of legal advice. This information is generic, and it's not going to necessarily meet the needs that your personal case or situation may need. So listen up, learn a lot tonight, and then if you have a case that you think we might be able to help you with, you can learn more about that towards the end on how to contact us. But I hope you learn a lot, and I'm going to start by asking Miles to tell us what heirs property is all about.
Good evening, everybody, and thanks so much, Patricia. Heirs property or heirship property is essentially family land. Some people also refer to it as property with tangled title, but the basic definition is real estate that you inherited and that you co-own with someone else. That's the basic definition. The legal definition is also important because the state of Tennessee gives certain rights and creates certain rules around heirs property. So I'll address the specific legal definition as well. In Tennessee, heirs property has 3 factors. First, it is co-owned by 2 or more people. Second, at least one of the co-owners has to have gotten the land from a family member. And that can be inherited from a family member or bought from a family member, either one. And then third is an either or. Either 20% of those co-owners have to be related, or if the co-owners are not related, then the person who got the property from a family member has to own at least 20%. So that's what heirs property is in a nutshell.
What kind of legal problems does heir properties create, Miles?
Well, heirs property creates a lot of legal problems, but it really starts with a legal problem as well. And that problem is not having a will. So if you don't say who gets your things when you die by writing a will, then the state essentially writes one for you. They decide who gets your things. If you have multiple children, then the state is going to say that all of them are going to get an equal slice of what you owned during your life. And that's even if what you owned can't really be divided. So for instance, if you own one house on 1 acre, it doesn't matter that all 10 kids can't really own and use that house together. They're all going to get it if you didn't write a will that says one person gets it. So that's how we start. That's how heirs property is usually created. Either the person who originally owned the house didn't have a will, or they had a will and they just leave the house or the land to multiple people in the will. And that's how we get multiple owners.
Well, Miles, if I was to inherit a piece of property with 7 different siblings and I pay the taxes every year and my name is in the will, is that mine if I pay all the taxes?
No, and that's a really important question. It's actually a very common myth about how property ownership works. If the will leaves a property to multiple people, or if there's no will at all and there are multiple children of the original owner, then that means that all of the people involved, either all of the children or all of the people named in the will, own the property in what's called undivided interest. So that means that all of them can use it how they want to. And obviously that creates problems because not everybody is going to agree on what happens with the property. Just because you pay property taxes, just because you live in the property or taking care of it, doesn't mean that you necessarily own any more than anybody else. It creates legal problems because people think that they own more because of doing those things. And then we actually have a chart showing how your interest in a property can get passed down. So just to break this down, how is your property passed down if you do not have a will? Like we said, the state essentially writes a will for you. And so we'll use this as an example. Let's say I'm a property owner. My name is on the deed. Let's say that I had 5 children during my lifetime. When I die, the state is going to start with those 5 children in the assumption that all of them now have what we call an undivided interest. They all own equal parts of the property. But one of those children, child number 1, they died before me and they didn't have any children. So now we're only dividing the property between 4 children. Another common myth is that if I had 5 children, and as in this case, only 2, child number 3 and 4 who are in green, only 2 of them survive me, then the property is just divided between them. That's not true. When you leave your property to somebody via not having a will, if they've already died, then their interest in the property gets passed down to their children or the next generation. And that's one of the issues with heirs property, is that it keeps multiplying. So as long as each generation keeps growing, there are more and more people who own the property and more people who potentially disagree on what to do with the property. Probably the biggest issue with heirs property is that any of these people who co-own the property can force a sale of the property as well. And that's not just forcing a sale of their part of the property, but if it's a property that can't be divided into, in this case, 6 different parts, then they can actually get the court to sell the entire thing, even if they're the only one who wants to do it. So if we use this chart as an example, go to owner's child number 5, they have great-grandchildren who only own a 6.25% interest in the property each. All it takes is one great-grandchild with that 6.25% interest to say, I want to sell the property. And for the most part, the state law says that that has to happen. And the fact that your property can be so quickly taken out of the hands of your family because of the way that it's owned is the major issue with heirs property.
Your chart also illustrates very well, I think, that a grandchild or a great-grandchild could get the same portion or percentage as a child. And so I think
Yes.
that sometimes leads to misunderstandings within the family as to, well, why is this grandchild getting more than the other?
Yes.
But I think your chart illustrates that very well.
Exactly. That's another myth. Oftentimes people think that it depends on, how many generations you were removed from the original person whose name was on the deed, and that determines how much ownership you have. That's not the case. Some people think that if you're the oldest child, then you have the legal right to make certain decisions, and that's not the case either. So it really illustrates the importance of making your own decision about who gets what after you're gone, so that the state doesn't create this sort of mess for you.
Would you like to tell us a little bit about how we can avoid heirs property?
Absolutely. The primary way of avoiding heirs property is simply by making a will as soon as possible. If you buy or inherit property, then that is a perfect and important time to make a will, and ideally to leave that property to one person. Sometimes making that decision to leave it to one person is controversial, but it's important to remember that leaving it to everyone, leaving it to lots of people, makes it valuable to no one, essentially. And we'll talk about why that is in a moment. But just on the point of deciding who to leave a property to in a will, if you have lots of people to choose from, you might want to make the decision based on a variety of factors. Who do you think in your family needs housing? Who do you think is financially able to keep up with the mortgage if there's a mortgage? Who's going to be responsible and able to pay the property taxes? So think about why you want to leave the property to your family. What goal is it accomplishing? And then who is going to be able to benefit from that goal, and who is going to be able to actually keep up with it as well. Now, on the topic of a will, some people might want to wait to make a will. Maybe they think circumstances are going to change, and they want to make sure that the will reflects whatever life event they think is going to happen in the future. What if I'm going to get married or have children? But it's always a better idea to make a will now, and you can always write a new one. You can always add something to your will when you have a life event. But making it as soon as you know that you have, this important asset like a home or land to pass down is critical to preventing heirs property. And I do want to address one myth about wills. Lots of people think that if you name someone in your will, that person then becomes responsible for the debts that you accrued during your lifetime. And that's not true. No one else is responsible for the debts that you have accrued while you're alive. Your estate is responsible for your debts. And that means that if you owe money to somebody, then after you die, whoever you owe money to can try to get the money out of the things that you owned during your lifetime, but they can't come after your family members personally. And so there's no reason to wait until you're debt free, for instance, to write a will, or no reason to worry that you shouldn't name a family member in a will because you don't want them to inherit your debts.
So what should people do if they do have a family member who owned a house or land recently died? I guess the first thing is to figure out, is it even heirs property? But if it is, what should they do?
Yeah, that's true. So if someone has recently passed and they owned a house, then one of the main questions is whether or not one should go to probate court. And if you're not familiar, probate is just the name of the court process that families go through when their family member has passed away and they want to get title to that family member's property. And this doesn't just apply to, homes and land, but especially for homes and land, someone would have to go through the probate process to actually get new names on a title. So whether or not the person who is deceased has written a will, the family is still going to have to go through the probate process if they're trying to get the property retitled. The difference is if the person has written a will, then the property will be titled to whomever's name is in the will. If the person did not write a will, then the property is going to be titled to all of their heirs, meaning their children, maybe grandchildren, all of the family members who the court says have a right to the property, what we were talking about, the state writing the will for you. So in terms of what you were saying about determining whether the property is heirs property, Patricia, it's a good idea to maybe start with a family tree and looking at, how many children did this person have? This is all in the context of if the person did not have a will. How many children did the person have? Are all of those children alive? If there are any deceased children, how many children did they have? Once you have gotten to the point where you have all of the living heirs, then you're at a good starting point of a best guess of who has an interest in the property. And if you are going to go through the process of trying to get this property retitled, you know that all of those people are going to be decision makers and have a say in what's happening. But I do want to say about the probate process that it's not necessarily in everyone's best interest to run directly to court after someone who owned a home or land died. And there's a few reasons for that. First, going back to that family tree, if you are trying to, preserve that property and you haven't come to an agreement with everybody yet about what's going to happen to the property, then going to court is going to notify all of those people that you have opened the estate. And so it's important to do your own research, contact all of those family members, and try to come to an agreement beforehand so that you don't go into the probate process blindsided and being surprised by what other family members' wishes are in terms of what to do with the property. Another reason for potentially not rushing into the probate process is what we talked about earlier with the fact that family members are not responsible for their family members' debts personally, but the estate of the deceased person is responsible for the debts. And so for the estate to pay those debts back, an estate actually has to be open. And when you go to court, that's what you're doing. When you go to probate, you're opening the probate estate. So if the person who is deceased has left major debts, then by going to court, you are inviting the people who they owed money to try to get their money back out of their things. So that means, selling valuable things that they had. And depending on how large those debts were, that can even include home or property. So there's some timelines that are significant to that topic. For most debts, for someone who is deceased, the people and companies who the deceased owed money to have 1 year to make a claim against their estate to try to get their money out of the deceased person's things. And if they don't do so in 1 year, then when you go to probate court, they can no longer try to get their money out of the estate. So for some people, it makes sense to wait that year before going to probate court. There's a separate situation, which we won't get into in detail here, but as many people know, if someone is enrolled in nursing home care and the state is paying for that care via TennCare, that there's a program called estate recovery where the state actually puts a lien against that person's property after they pass, and they will, execute that lien by having the property sold if necessary to get their money back. And TennCare actually has 4 years to try to get their money back from a deceased person's estate. And so that's a very hard situation to be in. And TennCare usually is going to aggressively pursue that anyway. But if you did find yourself in a situation where you were trying to avoid having the home sold by TennCare, then you should know that it's not until 4 years after the person has passed away that TennCare is barred from trying to get their money back.
So if I'm somebody that has somebody's will, do I have any responsibilities once that person passes away? Do I have to give that to somebody or?
Yes, and thank you for bringing that up. So I want to make a distinction between you don't have to go to probate court immediately or at all after somebody passes away. But if you have their will, you do have to provide that will to anybody who is named in the will. So if you're the executor in the will, meaning that the deceased person made you designated you as the person who they want to go to court and submit the will to court, you don't immediately have to go to court, but you do have to tell all of the people who were supposed to be getting things in that will that there was a will and that they are named in it. And you have to give them a copy of the will if they want it. Not giving them a copy of the will is actually illegal. And so you don't want to get yourself in that level of trouble by trying to hide a will. So I want to make that distinction. The court is not mandatory, but giving the will to all of the people who need it is mandatory.
So we've talked a little bit about whether or not you should go to probate after someone's passed, but I think with heirs property, what we see is that somebody's passed away years and years and years ago, and now the family's just discovering there's heirs property.
Yes.
So, and let me just back up one thing. Miles, we're going to get to it in a few minutes, but you do help people by giving them advice on whether or not they should go to probate or whether it might be in their best interest to wait a little bit.
Yes, absolutely.
All right. And we'll get to that more at the end, but I did just want to flag that. So like I was saying, if I do discover heirs property, what should I do? I mean, it seems overwhelming.
Yeah, and it can be. There's no one size fits all solution. And the real answer is it depends. That's not, what everybody wants to hear, but it really does depend on your situation and what your goals are and what's at stake. Do you live in the property? Are you trying to keep a roof over your head? Is this about preserving your family legacy? Is this about preserving the asset for your family? And then once you've made that family tree that we talked about, what are the opinions and preferences of all of those other people in the family tree? I still say that the family tree is the best place to start because you want to know who you are dealing with. And, working with an attorney to make sure that you know exactly who the heirs are is going to be the most concrete way. But if you find out who those heirs are, then you can have a conversation amongst all of the decision makers as to what needs to happen, because ultimately that's the group of people who you're working with. If everyone agrees on what to do, then you could move forward with probate and get the deed retitled. Sometimes people are going to consolidate their interests, meaning A family member says, oh, I don't want my name on that property. I don't live there. I live in a different state. I'll give my portion to you. Family members come to agreements amongst themselves. Maybe family members are going to exchange money between their hands and decide that people are going to, pay for their different interests in the property. Now, if people are not in agreement, which is often the, scarier situation, then you might find yourself in the situation of trying to keep the property from being sold. And that's when it's important to know whether you fit the dictionary definition of heirs property, because if you do, then the state gives you special rights. And the most important of those is really that if someone wants to sell the property, then you have as a co-owner, you have the right of first refusal, meaning that you can purchase one of the co-owner's rights and one of the co-owner's interest in the property, rather, before they get to sell it to anybody else. And that's definitely a process that you would also want to be in contact with an attorney about. But that's important to know that you have that option if you are trying to preserve property and everybody is not in agreement.
And so when you're creating your family tree, what I've often heard is you sometimes have to speak to the older members of your family. You need to get the family Bibles. You need to look through those records, maybe go to the property records and pull deeds. Is that what you generally would suggest?
Yes, and of course, that's going to depend on how far back the heirs property goes. So if, it's been several years, but the person whose name was on the deed was your parent or your grandparent, then it's a possibility that everybody who is an heir. It's just a matter of determining, the law, like which people are heirs according to what the state says. Once you start getting to grandparents and great-grandparents, if the last person's name who was on the deed was from 100 years ago, you don't know all of these extended family members, then those are good places to start. You can look up the original deed at your county register of deeds. You can speak with the elder members of your family to try to start creating the very first generation of the family tree, all of the children of the person whose name was on the deed, and then start from there by going down to try to get a best estimate. Because again, it's important to try to have that internal family conversation before moving forward and trying to get into a court process.
And one practice tip I would share is that when you're looking at the Register of Deeds, we've done a lot of advancements in the last few years and everything's online, but not everything is online for the online Register of Deeds. They have only really uploaded things from maybe 1980 and now. So if you're talking about property that's still in your great-great-grandmother's or grandfather's name, you're going to have to go to the physical office and look in the old books.
Yes.
So I just want to make sure people know if you get online, you search, you can't find it, doesn't mean it's not there. It means it's in the book. So
absolutely. And exactly. The online resources are just that. They are a resource, but the Register of Deeds, all of the folks at Registers of Deeds that I have spoken with have been great. I will call the Register of Deeds. They will help me find the book. I just called them today trying to look for a deed, and it was just that exact thing, Patricia. The deed was from the 80s and it wasn't in the online system. I assumed that it would be, and so the person had to physically find it there and email it to me. So that the Register of Deeds is a great place to start, but you might need to actually go in person or call them and get your hands on the physical deed.
I am so sorry, Mom.
No worries.
Sorry about that. So before we go into how legal aid can help, I'm so embarrassed, but I'm going to just keep moving.
No worries.
Before we get into how legal aid can help, I want to ask you a question. Why is this so important to you? Like we've talked a
Yeah,
lot about it, and I can tell that you're passionate, but I want to know from you, why is this so important?
thank you. So it's important for many reasons. So first, um, on a large scale, sociologists estimate that about half, 50% of land owned by Black Americans is in the form of heirs property. And that is a lot. It's a lot compared to any other demographic group as well. Specifically, that heirs property is concentrated in the South. And the fact that heirs property can be easily sold out from under a family is actually considered a number one factor in the loss of property ownership amongst Black Americans over the last century. Um, if you're not aware, the phenomenon that's called Black land loss is essentially what that's referring to. And it refers to the fact that the amount of land that is owned by Black Americans in the US right now is somewhere around 10% of what it was at the beginning of the 20th century. And so that's really hard for many people to wrap their heads around because we think about, all of the progress that has been made since then in many other respects. But in terms of this very important issue of property ownership, there has been a lot of going backwards. One of the reasons that property ownership to me is so important is because home ownership is the number one way that Americans build wealth. And if Black Americans are disproportionately losing their property, home ownership rates amongst Black Americans are lower now than they were in 1968 when the Fair Housing Act was passed, then that means that Black Americans are not in a position to take advantage of the number one way that Americans build wealth. And I think that preventing heirs property from continuing by doing something as simple as encouraging as many people as possible to write their wills and actually be able to, state what they want to be done with their property that they earned in their lifetime is really important. And then just on a personal level, I've seen a lot of heirs property growing up, and I've seen all of the legal and personal and housing and financial consequences of forebears not having written a will. And so as an attorney, I think that it's great to be able to help people create estate plans, prevent heirs property, go through the process to try to keep property within their family and create more opportunity for their future generations.
I really appreciate you sharing that because I think it really shows people that you care about this. And so we are the place to contact if you have questions about heirs property, because this is your project and you are really passionate about it. And I've learned that from working with you, but I want our audience to also realize that.
Thank you.
Sure. So what can we do here at Legal Aid? And I know that you're kind of driving the ship and I'm just back here supporting you, but what can we do to help folks?
No, I mean, so there's a few things we can do. I just want to start with the, clarification that we can't help everyone who contacts us, unfortunately. We are only so many people with limited resources. And to be a client at Legal Aid, you have to be income eligible, and your legal issue has to fit within our priorities. So that's a disclaimer. For this particular work, our focus at Legal Aid is on homeowners who want to keep their property in their family. And depending on whatever our current resources are, when you contact us, sometimes we can represent you, sometimes we can offer you some counsel and advice. maybe send you a letter, speak with you on the phone, and give you some information and advice on your situation. So that's just to set expectations. But in terms of what we can do, I see it in three different categories. And first is just avoiding heirs property altogether. And that's estate planning. That's writing wills. Like we talked about before, it's a good idea to leave your home to one person where possible. And if you are, your family situation is distinct and there's just not a way that you feel like you can leave it to one person, we can work on how to minimize the possibility of heirs property. So one of those things is when I have clients who say that we put in a right of survivorship in their will. That means that it actually creates what lots of people think is the myth. So when we talked about, there's a common myth of if you die without a will, you have multiple children, then the last child alive owns the land. That's not the case. But if you write that into your will, it can be the case. And so that's just one example of something that we can help people do with writing a will to avoid heirs property. Then the second category is kind of minimizing the consequences of heirs property. And that might be through the probate process. So maybe somebody has died relatively recently, and all of the family members are in agreement. That's an important thing for us because, as we said, we do have limited resources. And so we don't have the resources to be trying to go through the probate process. We're just trying to get things retitled and maybe pay off debts, get the estate closed, but we're having to deal with multiple family members who are in disagreement over what's happening. So in order to take advantage of representation and probate, the family members will have to sit down and be in agreement about what's happening first. But guiding families through the probate process and ultimately getting the property retitled into either the heirs or the people who are named in the will's name is another service we can provide. And then lastly, there is the services we can provide essentially to try to preserve heirs property. If you're trying to prevent your heirs property from, leaving the family, from being sold, and that would, usually mean that the family members are not in agreement, then that is something that we can sometimes offer counsel and advice about, and sometimes offer more services. And again, there's limited resources. Doing that is a big endeavor, and like Patricia said, that is what I'm passionate about. But we are working within our means.
Thank you, Miles. I think now we can head into some time for questions, unless you have something else you wanted to share with us.
No, thank you. I think that's it.
Okay, and we do have one question in the comment box, but that is getting into some very specific details regarding a divorce settlement, and I feel a little uncomfortable discussing this question right now. But I'm going to jot this person's name down, and we will have somebody at Legal Aid reach out to you. Like at the beginning when I said, well, this is just kind of generic, I don't want to talk about specific issues, but I will grab your name there in the chat box.
Great.
And we'll see if anybody else has some questions. I think that might be the only one. I will say that this video will be around for a while, much like heirs property, Miles. And if you have questions, it won't always be live, obviously. So you can go to las.org, and we have lots of informational brochures there. And I do want to say that as part of Miles' project, he is doing several different community educational pamphlets. And one of them is, do I need a will? And other basic information about wills. And that will be coming to our website, hopefully within the next couple of months. And again, that's at las.org. And I don't think we've got any more questions, Miles.
Okay.
But before we wrap up, I do just want to give you another opportunity to share any last words of wisdom or thoughts.
I don't think I have any last words of wisdom. I just encourage people to think about not waiting. And if you I mean everyone really, but specifically for this topic, if you own property, if you own a home, then don't hesitate in getting out there and making a will for yourself. We're going to share some contact information, and so I would encourage you to contact us. So the bolded number is specifically for heirs property issues. And then the second number, the 800 number, is for any other legal issue. You can be directed to the correct resources within Legal Aid Society. And then my email address actually is not very visible, but I will just read it. It is my first initial and last name. So you can see my name in white there. It's my first initial, M, and then last name, Malbrough, at las.org. And if you are an organization that is, working in the community, wanting to do some type of presentation, maybe similar to this, or maybe on a related topic, and you would like to see if we can present with you or coordinate in some way, then feel free to reach out to me via email.
And we look forward to having those opportunities and hope lots of folks will reach out to us for that. And before we leave, I just wanted to do one little public service announcement. Because we have been talking about homes this evening and preserving home ownership, I do know there's folks and families out there dealing with getting behind on their mortgage payments, and you still be struggling because of the pandemic. THDA, the Tennessee Housing Development Agency, has a program that is giving money to homeowners who have fallen behind during the pandemic. You can go to thdA.org and click on the Home Owners Assistance Fund block. But that program is closing August 1 or somewhere right around there at the beginning of August. So please, if you're needing money to catch up your mortgage, please go to thdA.org because there is money there. And thanks for letting me have a moment to do that, Miles.
Of course. Thank you.
We really appreciate y'all tuning in this evening and listening to Miles and I present on Heirs Property. Let's just be honest, it was mostly Miles doing the presentation, but I think he did an awesome job. And I really appreciate everybody that was able to join us. I think there's another one of these next week, so you'll hear more about that in the future. Thank you. Have a great evening, everyone.
Good evening.